All right. Thanks for joining us today on CSP's Vital Talks. Vital Talks is our series designed for members to remain and become the top performers in our industry. And we're so glad you could join us today. Our VITAL acronym stands for V for Visionary Thinkers, I for Integrity, T for Training, A for Advocacy, and L for Leadership. And today's Vital Talk is about training. We have the esteemed speaker of Jonathan Light, from Light Gabler. If you've never heard Jonathan talk before, he can take a tough subject and really make it interesting and also understandable. And he just moves things along, and he's got 2 hours of amazing content to cover. So he's got a fantastic profile. You read more about him on his website. And also here, just real quick, he is a super attorney, so a super lawyer, and to me, kind of a superman, because he's been with us with CSP for many years, and he's been at conferences, and during the pandemic, he was out there with us when we would have our special events for members, and we're just so grateful to have you join us today, John.
Well, thank you. That's quite an introduction. I got a lot to live up to now. Yeah,
well, wait, now there's more though. In addition, if you didn't know this about John, he's also a published author. He's written 2 award-winning books on baseball. So he's an expert on baseball. He's a big friend of the arts and all kinds of sports. And so, yes, sorry to interrupt you, but there's nothing average about John Light. I will just tell you that right now. You are in for a treat. So
thank you. Well, next time you have a live event, I will we'll do my baseball show as the entertainment at one of the meals, and even the baseball haters will enjoy.
You got it then.
All right. It said I was muted. Did you hear all that?
I heard you.
Okay.
Definitely.
All right. Man, look at all these faces. Oh, Sonia Robles. I have to quickly share, if you know Sonia, she and her partner at the time, in 1994, they asked me if I'd come talk about new laws to their local EAC group in Oxnard, California. We had about, I don't know, 60, 80 people. And then the next year it grew to 150, and then it was 300 for a couple of years. And that was the launch of my speaking career in 94. I'd been practicing for several years, but I can pinpoint it to Scott Goodwin and Sonia Robles in 1994. Sorry to age you there, Sonia, but there you go. Anyway, nice to see you. And I was just at her group on Tuesday. So I've been doing their group for 30 years. It's crazy. And this group, I've been speaking to you for several years. I've been to some of your offsites. Okay, so let's get started. It's the new laws. Some of you probably been to some of these already. There's a lot to cover. So I'm going to put up the materials, and then feel free to put questions in the chat, and then I will happy to be interrupted. I like to do it as we go, so it's timely to the topic and we don't move on. And if you have a question about something that we've already moved on, that's fine too. Just interrupt me and we'll go to it. Okay, so there's a pile of documents here. It's divided into 2 pieces. The first half is about 50 of the most relevant new employment laws for this year. The second half is the new cases from last year that will impact us going forward. I'll cover not all of those because we won't really have time. I did this speech yesterday for 3.5 hours and I got through everyone, but I won't do that here. And my voice sounds like hell because this is 9 speeches in 11 days, 3 today. I've already done 1 this morning for an hour, and Tuesday and Wednesday were both over 2.5 hours. So it's a little crazy right now, but it's still fun. More fun than going to court. So here we go. Okay, so I'm going to scroll. You can follow along. You should have these materials on your own, hard copy when you need them. The only really interesting thing about me is my kids. I have interesting daughters. One's in the Foreign Service. Her husband, the Green Beret, is just switched over to the Foreign Service. So the 2 of them will be posted in the Middle East probably because they both speak fluent Arabic. But she's the favored child now because we have a granddaughter from her named Paloma. And she's 13 months and we're in heaven. She's the coolest. I'm Grandpa Johnny, and it's very fun. And my other daughter's a performance artist in Germany, and we barely see her. We were in Germany to see her, and she said, "Oh, I just got a stipend to go to Iceland for 6 weeks and teach performance arts stuff." So we said, "Well, what about when we get back, on the back end of the trip?" She said, "No, I'll be in Serbia." And then she was going to Brazil and Poland. So it's nuts. And she's coming back to the States to go to a PhD program in September, we think. But as my wife says, why can't they just live in Camarillo and sell insurance? But it's not happening. All right, so let's get to it. So this is the big table of the contents. And then this is kind of an interesting thing. This is the Roman numeral 1, I think. I don't know why it's Roman numeral 1, but anyway, these are all the initials of the various things that we'll be talking about. If you forget which one's which, you can just refer back to this thing on your own copy. Okay, so let's get to it. Same amount of bills essentially as the last few years, around 100 labor-related bills. So not a lot different than the recent past. I suspect that none of you are farm labor contractors, but perhaps agriculture historically was not covered by the overtime rules. And so the law allowed harvesters to work 6 days a week, 10 hours a day with no overtime. And then the legislature started reducing that number. And so now every ag employer is subject to the regular overtime rules, except if you're a smaller under 25, you still have for 2024, you can see in bold, the 8.5-hour day and the 45-hour week. By the way, just a quick thing, make sure that your payroll service, whoever you're using, is doing the overtime correctly. About 4 years ago, one of the very big payroll services, big ones, was paying both the daily and the weekly overtime, and instead of paying the greater of the two. And I wrote an email to their rep. It was a little medical office that noticed it. And I wrote a letter to the rep, and they said, no, that's our algorithm. That's how we do it. You're wrong. And so then I wrote to her boss, and I got the same kind of snippy response. And then I wrote to their boss, who was apparently legal, because a week later, my client got a check for $17,000. And so my point is that if this big payroll service is screwing it up, God help the rest of us. So just make sure that you are internally presenting the numbers correctly to the payroll service, and then the payroll service is correctly issuing out the checks. Okay, so that's ag, probably not relevant to this group. Now, arbitration, we had a huge thing on Tuesday, the Ninth Circuit, which is the federal appellate court right below the US Supreme Court. They issued a ruling over this AB 51 that favors the employer. So most of you probably know that there's this huge tension between the state and the feds over the use of arbitration agreements with employees. The Federal Arbitration Act absolutely allows it, except for certain transportation workers, with 2 exceptions now, with sex harassment and sexual assault cases. But that's pretty narrow. Everything else, you can have arbitration agreements with employees, and the state keeps pushing back on that. So for example, the state has figured out a loophole to allow employees to pursue PAGA claims. And you probably are all familiar with PAGA, the Private Attorneys General Act, which is like a class action wage and hour case. The only good news is that it only goes back 1 year on the statute of limitation, whereas a class action can go back 4 years. So back to my point, the Ninth Circuit has said no more litigation about this. AB 51 is not enforceable to the extent it prevents arbitration with employees. Good news. Now, for your purposes, a couple of things. I'm a definite believer in arbitration agreements, and I think every one of your employees should have it. And I would strongly encourage you to urge your clients to implement it with their people, because when one of their people files a class action, it will drag in the staffing agency temps also. If your people have arbitration agreements, that will knock them out, and that's good, but it's a little value added to encourage your clients to do that. If you don't want to get involved in their business, that's okay. The one thing that I would do, and I've actually created this, is an arbitration agreement specifically related to staffing agencies. So it says that you are covered by this agreement between us, the staffing agency, and you, the employee, as well as the host employer at which you work. Because we've had some litigation, we actually won an appeal on a case where that was the issue. Was the staffing agency's arbitration agreement sufficient to cover the host employer? And because of some good language that sort of happened to be in there, we won. But in light of that, I've made a much more specific arbitration agreement. I'm happy to share that is targeted towards staffing agencies to protect you and your clients, because you don't want the client coming back after you. The other thing to keep in mind in your relationships with your clients is how you're handling your staffing agency agreement with the client and the issue of indemnity on wage and hour issues, because of course, meal breaks is still front and center. Rounding time, you just cannot round time. There's a couple cases in here about that. Do not round any time. And then on the meal break issue, your argument is, well, host employer, we don't control the work site, so we can't regulate whether you're doing meal breaks correctly, and certainly not rest breaks. The backside of that when I've been on the host employer side pushing back against the staffing agency is, well, yes, but the timesheets go to you, staffing agency, and you should be reviewing them to see if there's any meal break violations, and then alerting the host employer that, hey, these people are not getting their breaks too late, or they're short, or whatever. We need to clean that up for both of our benefits. And that's not an ineffective way to get you back on the hook for the meal breaks, because you're supposed to be looking at the timesheet. So just keep that in mind. And just as an overall proposition, the big four, the Achilles heel for you and the host employer is meal breaks, rest breaks, rounding time, and bonus gross ups. Are they getting some sort of performance gross up? They get an extra amount of money if they turn in, create a certain number of widgets. Depending on if it's a commission or some sort of bonus situation. If they're non-discretionary, which is a pretty broad net, then you have to gross up meal breaks, rest break, premiums, sick time, and overtime, of course. So just be mindful of those and do what you can to shore up those situations, both in terms of paperwork and your own handling of those people and your own internal people. All right. One last point, just on your relationship with your host employer clients. I just had another one of these in December that's kind of blown up. The host employer says, we want John gone, and staffing agency gets rid of John. Well, then John comes back with a letter from an attorney saying, I was discriminated in my workplace. I told my supervisor, who was the host employer supervisor, about some issue, and nobody has documented why John needed to go, the legitimate business reasons. And now they're making a claim against both employer and staffing agency because there's no paper trail about the bad things John was doing. And so it looks like, well, now we got some discrimination or harassment we have to deal with. And we don't really have the paper trail to push back and say, no, these are the legitimate business reasons why we let John go. It wasn't because he was disabled or whatever the category is. So anytime you get a request to get someone off the site, have a paper trail as to why. And you need to maybe enlighten your client that they can't just rely on at will, or that it's your problem as the staffing agency. They're the joint employer, whether they like it or not. And at will is not a defense as soon as somebody claims harassment, discrimination, or retaliation. You've got to document the legitimate business reasons. And there's a case about that in here as to how that works if we get to it. All right, I think that's enough on arbitration for the moment. It's alive and kicking. I highly recommend it. And then I also highly, highly recommend getting employment practices liability insurance. I have it. I've got 30 people here, and I have arbitration and I have VPLI. And the wage and hour rider, especially for a staffing agency, might be useful because you'll get at least about $100,000 of attorney's fees covered to defend the case. The rider on the EPLI does not pay off on a wage and hour claim, but you can get some of your attorney's fees covered. That's the benefit of the rider. And then wrongful termination, the tort case is harassment, discrimination, wrongful termination. You usually get $1 million of coverage, sometimes 2 million now, which is actually a hell of a lot better for those cases. And you should have that as a staffing agency. And sometimes it's required. The other thing that gets a little tricky sometimes is if you've got EPLI and the host employer is also covered by it, who's paying the deductible? And is that clear in your staffing agreement with the host employer? If they've created the problem, do they have to pay the premium? So, and depending on how sophisticated or how much clout your client has, they may push back on some of these terms, but usually the staffing agency's agreement is sort of signed off on by many employers without giving it much thought, and puts you in a much better position. Okay, let me move on from arbitration. Background checks. So nothing dramatically new here. You're all aware, I would expect, on the green rules. If somebody's got a criminal conviction, that you've got to balance it with the position and see whether you can still hire them. I got a call last week from a guy who says, somebody pointed out that one of my warehouse workers is on the Megan's list, sex offender list. What do I do? And we looked at it and we ultimately concluded that no, you can't fire him because he's not leaving the premises. There's no daycare on site. He's heavily supervised. There's no school next door. He doesn't have access to any records. And so there's no basis for terminating him. Now, the other thing is, I'm quite certain that you're all up to speed on your application with no social security number, no request for birth date, no request for emergency contact information. You don't need any of that till you made an offer. And then the criminal background you can't ask about at that point. And then the salary stuff. I assume you're all up to speed on that. I do have a case right now with a guy who he has pointed out correctly that the salary range in the ad was $25 to $29 an hour, and he started at 22. And not sure why there was a good reason for that. And so we're having a little issue there. So just be careful that the wage rates are broad enough and you don't get caught by one of those. Okay, so on this issue, oh, and also in your advertising, be very careful about putting things in, for example, and there's some reference to that in this number 5. Things like, looking for energetic workers. Well, that's code for young. And the EEOC has really cracked down on this stuff. Moving companies have been hit. Well, they don't have a lot of older workers applying for moving jobs, but they're getting hit for this because they advertise geared towards younger workers. They advertise on campuses. So you have to be careful about how you're advertising. And then things like must be able to qualify under the company's auto insurance because you're going to be driving a vehicle. That may cause someone to self-select out because they have a criminal conviction of some sort when they might have been eligible anyway and didn't know it. So be careful about putting those kinds of specific restrictions in the ad. That's going to come out soon enough at some point later. Now, specifically, the two differences now are 1 and 2 on the screen. So there was some issues about having third parties doing background checking that might be contrary to the rules in California. And so they've expanded the definition of employer to cover you and anybody else that might be working on behalf of the employer, what I'm calling the host employer. So that seems kind of obvious. And then the second one, not necessarily your problem, but so you could have an internal candidate who's up for a job that now requires another background check. And companies were getting around that saying, well, they're not an applicant, they're an existing employee. And so now this law says, no, that includes existing employees, so we're not putting up with that nonsense. So that makes sense. So those are the only two biggies on that one. All right, let me skip down. Restrooms, if you've got an all-gender restroom, it needs to be, if it's single-user restroom, it needs to be all-gender. That's pretty straightforward. For construction sites, by 2025, end of 2025, they're going to be requiring some single-user restrooms on construction sites, mainly because they don't have very many women and transgender people tend to be underrepresented out there. And this is a way to at least help encourage people who are not men to apply. Cal Savers, pretty straightforward, nothing changed here. Just a reminder, probably not an issue, but this is going to go down. It's 5 or more employees right now that you have, and then you have to have this. If you've got a single staffing agency, you're a sole proprietor with no employees. The third paragraph references that starting in December of 2025, so a couple of years from now, you will still not be required to have a retirement plan. It's one employee, meaning you are a sole proprietor and you have one employee. And so you'll be okay if it's just you and you don't have a retirement plan, although you might want to consider it because there's good ways to sock away money if you're sole proprietor and have a retirement plan set up either through a corporate entity or maybe on your own, but I'm not the expert. All right, food handlers. I'm not sure this group's providing staffing to McDonald's or restaurants, but maybe. The big point here is now that the food handler card and the training that they have to go through, that has to be paid for by the host employer. You cannot say, must have food handler card in hand to apply or to take a job here. If the employee or the applicant does not have it, then the prospective employer has to pay for it. And then the question is, well, when do they pay for it? If they're not on the payroll yet, and they took the food handler thing, when would we pay for it? And my opinion is that you just wait till they've got one paycheck and you pay it at the first paycheck. I think that's reasonable. Number 10 is
John, we have a question in the chat.
Go.
The question is, can a company require COVID vaccination?
You can require COVID vaccinations. I'm not going to talk about COVID today, by the way, but yes, you can require COVID vaccinations unless they've got a religious exemption or they've got a medical condition. Nothing's changed on that since COVID started and the rules were set out. Those are the two exceptions: genuine religious exemption. And it's not that your church may say fine, like the Catholic Church was fine about vaccines and was encouraging it. But if someone had a legitimate personal belief about vaccines based on their religion, that would be enough. So it's pretty far afield. The other issue just with religion real quickly now, as long as I mentioned it, there's a case in here about it, but it's become an issue for some of my clients when people say, well, I can't work on Sunday, I have to go to church. And because of the US Supreme Court ruling on this last year, it's become more problematic because you have to honor that. It's not that someone can't work between sundown Friday and sundown Saturday like an Orthodox Jew. It's they just have to go to church. And so we had a situation last year with a woman who church is over at 11, we'll see at noon. Oh, no, I have to do some other stuff in the afternoon related to my church. Well, get your minister to get us a letter. And of course, she didn't do that. She just didn't want to work on Sundays. So it's a little bit of an issue. But back to your question, yes, you can require COVID vaccines subject to those two exceptions. All right, so my HR review, I've got some large staffing agencies that I represent, and this is a great thing even for the staffing agency and also to help you do some value added for your clients to help them keep out of trouble to the extent you want to stick your nose in their business on things that could affect you, like meals and rest breaks. We've run into situations where the staffing agency comes to me and says, our client is letting people take their meal at 5.5 hours, and the client is telling us that it's okay because they're confused about the 5-hour meal rule, thinking it's after 6, up to 6 hours. So little things like that. This thing takes about 4 or 5 hours. We do a Zoom meeting with your team and go over about 120 topics. And then I do some follow-on action items for you and me and review some documents. So if you're interested, reach out, we'll do something. All right. The reason I'm not going to cover COVID, a couple of reasons. One, I'm sick of talking about it. Two, nothing has changed this year. Early in the year, well, first of all, the sick time stuff went away last December, a year ago. And then the Department of Health Services and the OSHA folks and the governor with their emergency orders had some inconsistent regulations, which they've now made consistent. So they're all buried in here somewhere. If you're interested, and I know in LA County, we've had some outbreaks. One of my attorneys was supposed to do an in-house training for someone down in Burbank Friday. And there's some issues about that because they've got a COVID outbreak and she doesn't want to do it. And the client still wants to move ahead. So we're having a little tussle over that. And remember, as of, I think, August, you do not have to report to your work comp carrier when you have a case anymore. And then number 12, this could affect some of you. This law is still in effect. It expires at the end of this year, or some of it does. Well, it did, and now it's been extended to 2025. Certain industries like hotels, airports, a few other things where employees were laid off, you have to give them notice that there's opportunities to come back to work for those who were laid off because of COVID. So just keep that in mind if you're in an industry or have clients in an industry related to this. And there's a big long list down at this paragraph here that's in the middle of the screen right now. Nothing new, just a reminder that this has it's been updated to extend it a little bit. That's all. The substance is not different. I'm going to skip 13. 14, the state's going to be doing some LGBT enlightenment for people around the state. My daughter in Germany is a non-binary, so I'm very sensitive to this issue and very supportive of it. My problem is I can't remember the pronouns. And so, they is very difficult after 30 years of she, and it's been they for the last 3 years. And I totally get it. And I'm supportive and I really try hard. And I don't mind being corrected by their sister and my wife. What really bugs me is when I get it right, the sister and my wife go, "Good job, Dad." It drives me nuts. It's like I'm a third grade boy and I got it right. All right. So that's 14, 15. Okay, so this is an action item. So any employee in California that wants, that the employer wants to electronically distribute certain documents, and that's pretty common these days with an intranet or a web portal or whatever, you have to have a specific opt-in by the employee. There's no specific language that's required. It doesn't have to be fancy, but somewhere they need to be able to check a box or respond in an email or something saying, I agree to accept electronic distribution of materials or access those materials electronically. Okay, 16, I'm not sure anybody here is providing staffing to fast food, but maybe. There's a new agency, the Fast Food Council, that's been created, which isn't completely out of left field. We have the Industrial Welfare Commission, which is the state agency that was defunded, and I think they just got some funding now. They create the rules that go in the wage orders. You're probably all familiar with the wage orders. And so this group is now, this FFC is going to create that kind of stuff for the fast food industry, most significant of which is this, where it says, what does it do? They're proposing to set a minimum wage of $20 an hour for fast food. And the fast food industry, you have to have at least 60 outlets for your chain for you to be subject to this law. There's been a legal challenge filed, so we'll see if this gets slow played here, but that's what's on tap if you have people in this space that you're working with. All right, some action items here with cannabis, handbook update. There's going to be a few things you're going to put in your we don't discriminate on the basis of age, race, sex, disability, military, whatever. And then you're going to have cannabis, off-duty cannabis use will be one of the action items. And there's a few more in here that we'll talk about. So a couple of things with cannabis. Nothing substantively has really changed. People can't show up high. They can't have stuff on property. If they get caught smoking weed and they smell like weed, they're too stupid to work for your employer, because there's a little thing called gummies. And if they're not smart enough if they're really going to get high at work, if they're not taking gummies and they're smoking weed, they're really stupid. So get rid of them. But again, nothing's changed. You can still do pre-employment screening. You can still do post-accident, reasonable suspicion, safety sensitive if it's the correct position. Nothing's changed there. The big takeaway now is, because we have recreational marijuana, the state's saying you can't discriminate against people for using. If you're supplying workers to a federal contractor, they may be bound by the federal drug-free workplace rules, and so you still have those rigid rules. I've got clients that just don't even test for marijuana now. My advice, unless it's a contractor situation, federal contractor, is to treat marijuana like alcohol. Don't show up high. You want to get high on Friday night, you better be ready to go on Monday. You want to get drunk on Friday night, same thing. The other big issue with 17, and I think it's also in 18 here, I'm just going to move over to my notes quickly so make sure I don't miss anything, is that you're no longer going to test for all marijuana. You're going to test, well, let me break it down a little bit. THC is the active ingredient. THC in its THC form will show up in 24 to 48 hours, and then it starts to break down by the body. And it breaks down into what are called metabolites. And if you did a hair follicle sample, the metabolite would still be in there for months or years later. So you can't test for metabolites anymore, because the state doesn't want you to know if they've been using marijuana more than 24 to 48 hours earlier. And they only care about current use, because that's what would impair their ability to do the job. Now, this is not applicable to construction. That's the one exception for now. We shall see. And some of my clients aren't even testing for marijuana. So two things. Number one, if you are doing testing or it's required by your client, make sure that the testing lab is not testing for metabolites. I got to believe every testing lab is totally up to speed on this issue, but you might double check. And the second thing is, you might check with your lab to see what level of THC is a positive. Is it 20 nanoliters, or is it 50 nanoliters? Those tend to be the two that they use. And obviously you're going to catch a lot more people at 20, and you may not want to. So that's really up to you. By the way, very quickly, my favorite story on this subject, several years ago, I had a landscape maintenance guy at a hotel. He'd been there 25 years. He got caught smoking weed in a shed, and they didn't want to fire him. So we put him on a last chance agreement. We can now randomly test you because you smoked and you got caught, We're not going to fire you, but if you want to keep working, we can randomly test. Okay, he signs it. 2-3 months later, no pun intended, he's getting a little pissy. So they told him, go take a test. We get a call from the lab. Temperatures, the sample is room temperature. He got it from his buddy. He doesn't want to do blood. He says he won't pee again. So what do you want to do? So we sent him home, and I said, just test the sample anyway. And so we did. His buddy's urine came back positive for cocaine. Not the smartest guy in the world. That'd be the guy who's still smoking weed today instead of taking gummies. All
So
right.
John, there is another question too on that. Just to clarify about off-duty cannabis.
Yep.
Is an actual protected category, just as far as
It is a protected category. If you look at number 18, let's get down to that. Okay, so you cannot discriminate against an employee. You can't seek information relating to their prior use of cannabis. You can't use information about their prior use obtained from criminal history, unless there's some specific exceptions or federal law because you're a federal contractor, perhaps. And there's certain positions for like Defense Department or requiring security clearances. But in general, past marijuana use is not something that you can inquire about. And current use, I would stay away from also, unless it's medically related. But even then, in medically related situations, you can find an alternative and say, just like it was 5 years ago with medical marijuana cards, which we don't really see much anymore because people don't need them as much because they can just go get it on their own, is that if your doctor says you have to use marijuana, we can't allow that in this work environment because of safety issues. You're going to have to get a different alternative, let's say pain medication, not Vicodin if you're going to drive a forklift. So nothing's really changed in those areas in that respect, but this is really related to not inquiring and not discriminating against someone for recreational past marijuana use.
John, what about post-accident drug testing?
100% you can test, but you can only test for THC unless it's construction. But you can still do post-accident. The one key little tiny caveat to that is a few years ago, the Cal OSHA issued an edict that said you cannot drug test an injured worker if they had no part in the creation of the accident. So you're a passenger in a pickup truck, there's a car accident, you were asleep, you get hurt, we can't test you. Something falls off a shelf in a warehouse 12 feet up and you didn't bump the shelf or anything, you're not getting tested. There's 99% of the time the employee's getting tested because even if they tripped on a rug that didn't move, that rug that mysteriously jumped up but really didn't, they were negligent in some way, we're going to test. But overall, you're still able to do post-accident testing, no changes there, just not metabolites. That's it. All right, moving on. This is not for you. The state and the UCs and the Cal States have to identify students in accordance to their new gender name if that's an issue. All right, number 20, this is relevant. You probably all know about the new I-9 form as of November 1. This is sort of a tricky one for your businesses because of remote verification of I-9s. Up until August, you could do that because of COVID. You could do it with a Zoom call with a person. They send you their stuff. You match that up with their face on the screen and you go from there. You may continue to do that only if you use E-Verify. If you do not use E-Verify, you cannot do remote verification anymore, but there is a workaround that they allow. And by the way, before I forget, the difference in the new form as of November 1 is that it's got sections 1 and 2 are on a single page, make it a little easier. Section 3 is in a supplement, doesn't get used as much. And then that's it. And so then back to the workaround. So you've got an employee that you're hiring who's based remotely, even in another state. You may engage a local agent. An agent is a general term. It can be anybody. It doesn't have to be a licensed anything. Get a notary or if you want, but it doesn't have to be. I can see people creating a cottage industry for this and making some money off this, because what you do is you hire that person. They are your eyes and ears. They represent the company. they will go out and meet with the remote employee in Milwaukee or St. Louis or wherever and sit down and verify their documents and then sign off on the I-9. And then you're good to go. So that's your alternative if you're not, not using E-Verify. Independent contractors, no change there. Yeah, they've extended some of the exemptions, but you're not too worried about manicurists and newspaper delivery people. I think I'm the last dinosaur on my block to get a newspaper delivered to my house every day. It's kind of pathetic, but there it is. The LA Times is a shell of itself. It's really sad. Okay, just remember this ABC test. I don't think it's going to come up for your purposes, but who's controlling the means of production, the A test, that's usually not the issue. The B test is usually the problem. They're performing a job that is integrated into the company's regular business. So that blows the B test. And the C test, and you have to meet all three. Do they have their own business? And are they holding themselves out and doing, they don't have to do work for other people, but do they have their own business license if required, etc. So again, probably not all that relevant for staffing agencies, but just FYI, that ABC test is a thing. It's here to stay. It's not been modified, and it's pretty tough to get around. There are some industries with some carve-outs, like golf caddies at country clubs. There's an exception or an exemption. Tutors, translators, but again, probably not relevant to your businesses typically. Okay, this is an action item for your handbook. Oop, tricky finger here. Reproductive loss. So this is a new category, probably put it after bereavement because it's very similar to bereavement. Let me just get to my notes here. So on this, you can see in the first paragraph, adoption failed, surrogacy failed, miscarriage, stillbirth, in vitro didn't work, stuff like that. All of those things are in this reproductive loss category. And just like bereavement that went into effect last year, you have to give them 5 days unpaid time. So it's very similar to bereavement in that respect, including the fact that they can use any accrued sick time, vacation, or PTO to fill in the 5 days. There's two other differences between this statute, or two differences between this statute and the bereavement statute. The first one is that bereavement was unlimited. You can get 5 days anytime the designated family member passes away. In this law, it's capped at 20 days a year. Now, if anybody went through some of this 4 times a year, that'd be terrible, but there is a cap. The other thing is that you can't ask for medical information about the situation because that would be a HIPAA violation, which is separate from bereavement, where with bereavement, you're entitled to ask for proof of the death, which is typically the announcement in the newspaper or the flyer at the memorial service. I mean, you could ask for a death certificate, but I'm not sure I'd really push that. Anyway, so that's the reproductive loss, and you will put that as a separate policy and in your laundry list of protected categories that you don't discriminate against. All right, next up, I'm going to skip 23. LA, I'm going to skip that. This is kind of interesting, and it's the coming thing, and there's a couple cases on it that might be of interest to you. So this law is directed towards large retailers with at least 300 people. And it's this business about, let's say Walmart has a big warehouse facility, and they bring in workers, bunch at a time to unload and distribute pallets that have come in. And so they tell the workers, call in at 7 a.m. We'll see if we have work for you at 9. And they get told, no, the pallets didn't arrive. You can't work today. And so the cases, and now this statute in LA, have been saying that you have to give them reporting time pay, even though they didn't physically show up at the site. So they get there, if they were scheduled for 8 hours and didn't happen, they'd get 4 hours of pay. And I think this is sort of the coming thing, because especially for gig workers, or well, gig isn't employment technically, but for workers who are living on the edge and doing this kind of work, if they block a day thinking they're going to get work and then don't, they've had childcare they've tried to arrange, they've incurred an expense, they didn't take a different job, and suddenly they're out income because they blocked and then are being told by the big employer, sorry, don't come in because we don't have work for you. So this could start to happen, and it would be relevant to some of the people or some of the companies that you deal with, I would expect. All right. This other one, I don't think this is really an issue for you, is freelance workers in LA have to be given a written contract. These are one-off people. Let Hannah in. All right, that's just a couple of rules. There's also a San Francisco military sector leave. If you're in that situation, I'm not going to go through it. Frankly, I haven't read it in about 3 months. I don't remember the details, but if you got San Francisco people, read this. There's a small group of people that this would relate to. All right, nobody's got airline cabin crews. All right, 27. It's sort of it's codification of law that we already thought existed. This Arthur Anderson case. Basically this, and this is something as staffing agencies you need to look out for too with higher end workers that you may be hiring, like an engineer, for example. They may have a confidentiality agreement, and clients will call me and go, I need a non-compete. Well, what they really need is a confidentiality agreement because non-competes are not enforceable in California. And basically, somebody goes to work for the competitor, you lose one of your salespeople on your admin staff, and they go to work for the staffing agency down the street. They technically are allowed to send an announcement to the clients that they have worked with to say, I'm now working for ABC Staffing. Here's my contact information. That's legal. You can't prevent that. What you can prevent is them taking it a step further and turning the announcement into what's called a solicitation. Hey, it's John Light. I'm working at ABC now. Here's my contact information. So far, so good. And we can beat their prices. I'd like to get your business. Let's have a meeting. Those kinds of things are solicitations based on the use of proprietary information, the client list, and that you can still prevent. So the only true non-competition agreements in California that are enforceable are those involving an owner of a company who sells their business and is precluded from competing for 2 to 5 years in a certain geographic area or broader if it's a bigger company. Those are still enforceable, but it's the regular employee situations that you just can't prevent them working for your worst nightmare competitor. So this is basically just codifying existing law because California is very liberal in favor of employees on this issue. The other thing that I see a lot is these agreements that will have, you cannot solicit our employees for a period of 1 year to come work for you or your new employer. That's not enforceable. It's a restraint on trade under the 16600 of the Business and Professions Code. So you can't do it. And what else? And then if you do hire someone who's got one of these kinds of agreements, you have to give them a notice that it's not enforceable. The other thing that's interesting, let's see if I can find it quickly in here. Well, 28 and 27 go hand in glove. They're very similar. This basically relates to contracts. So you got a Texas employee who now is going to work in California. Their Texas employer, or you had an agreement with them that under Texas law was enforceable. You can't work it for a competitor for a year. You can't solicit our people. That's not enforceable if they're now working in California, and you have to give them notice that it's not enforceable. And it gets a little tricky when they come from a different company that might have an enforceable Texas agreement on this subject, but now the person's in California. California would not enforce it. If it's somebody who's significant enough to the former employer and they want to go after them, they'd have to sue them in Texas under Texas law, and there's going to be a fight between Texas and California law. By the way, keep in mind that for anybody who's in California, you cannot have any type of agreement, commission, employment, confidentiality, that is subject to the law of a different state. It must be subject to California law. Also, just to help as a little value added for your clients, if you're supplying any workers that are going to be on commission, all commission agreements for California workers have to be in writing and must be signed by the employer. By the way, just so I don't forget, because this has become an issue with arbitration agreements, there's a couple of cases now that say that that management should sign off on the agreement, the arbitration agreement, so that it's a bilateral agreement. And we've had some situations lately where there was no signature by the management, even though there was a signature line. And it's been a little bit awkward where we get that from our clients as we've gotten a demand letter and it's not signed. So we've told them, sign it. There's no place to date it. And then hopefully nobody ever raises the issue of, oh, really, that's interesting. When did you sign this? So just be very aware that you need to dot your I's and cross your T's on that kind of stuff, and make sure that when you get those documents back, somebody in management signed it and it goes in the file that way. A little off topic, but I didn't want to forget that, even though I was going to cover that later, but I don't want to forget. So commission agreements must be signed by both and must be in writing. And I see a lot of commission agreements that have flaws in them. If you, or like for your own administrative team who are getting commissions on the employees they place, you might want to run those by me because there's some flaws in there. I actually did a full-blown, well, we arbitrated, but it was a trial arbitration with a former staffing person as to whether they were owed perpetual commissions for all the workers they'd placed, because there was nothing in the agreement about that subject. We won the case on some good testimony from the owner. You know, we had to put this with another staffing manager, and they had to service the client, and so they would get the commissions. But the agreement needs to be very clear about what they get and don't get post-termination. 29, this is not new. This is the federal law. Just a reminder that anytime you've got a, let's say usually in a separation agreement or a settlement agreement with an employee, based on there's issues of sexual harassment or sexual assault, you can't put a gag order in the agreement. Because normally we used to pay the money and say, you can't talk about the underlying case. For sex harassment and sexual assault disputes, now they can, if they choose to, even after they've signed. They can't talk about how much they got, but they can talk about the facts. So far, I have not had anybody actually do that, but it's a thing under federal law, so just be aware of that. And just as a general point, I always want to be careful on federal versus state law. Every once a year or so, I get a client going, you know, I was reading on the internet, and it says here something that tells me that that's not what you told me. And I have to clarify, this happened, I forgot this happened this week. The guy is a home care worker, and he found some law that said that this person under the federal companion law is not subject to overtime. Well, that's true, but this person spends more than 20% of their time doing cooking and cleaning and shopping and travel, so they don't qualify. I had to explain why the state law preempted. So you have to follow the law that most favors the employee. Another great example is comp time, compensatory time off. The state has a labor code section that's in the 230s, I think, that says what you would assume for comp time. You work an hour of overtime and you want to not get paid for it, you want to book it and save it. So you get an hour and a half of banked time for that hour of overtime that was worked. State law would allow that. But the feds, unusually, have a special carve out for private sector employers that does not allow you to bank time like that and go into a new work week. So they tried to fix that during the Obama administration and they couldn't get it passed. So private sector employers cannot do banked time, which seems stupid, but that's the law. And you have to follow that because in that case, it's federal law that trumps the situation. All right, 30 for OSHA. No action items for you. We've been waiting for 7 years, now 8 years, for these indoor heat regulations to get finalized. Finally, it looks like this year we're going to get those regulations. You know, you've got a restaurant, you know, a hot kitchen. You've got a manufacturing plant where there's a lot of heat for some reason. I remember going down to one of my clients down in Inglewood that does meat processing, and they were, you know, making millions of hamburgers for Costco and school systems, like $100 million operation. And it was bloody hot in that place. So anyway, these are finally coming to the extent that's relevant for your various host employer clients. I'm not going to go through the details. All right, so this one is sort of interesting for you as staffing agencies, for your workers that are on site at the host employer. If they're getting stalked, they're being harassed by a boyfriend or somebody, woman works at the plant and the boyfriend's coming around and hassling her at her car or trying to get into the place, or maybe it's one of your admins. So we've always had the ability to go get an injunction, temporary restraining order. They have a hearing. Now it's a preliminary injunction and it will sit in place for some period of time. And they've historically, you can get them, but they're not easy to get because the courts have traditionally required that there had to be a credible threat of violence in order to get this in place. And the reason why it was hard is because once it's in place, it's now part of their permanent record for that person. And so if they ever try to get a job, it's going to show up in a background check. This statute has softened this a bit in two ways. One, sometimes the employer will perceive a threat not only to the victim, let's say the girlfriend in this case, but also to other workers on the property. And of course, with all the mass shootings, that's a legitimate risk these days. So the employer can go get an injunction even if the employee does not want to participate. So that's one thing. And then the other thing is that the standard for getting the injunction has been softened. So you don't have to show a credible threat of violence anymore. It's more related to harassment that could have or is likely to occur on the work site. So that's another way that you can try to get one of these injunctions in place with that lower standard. The other thing that is going to happen here, middle of the page, in fact, I'll get down to it, is that everybody's going to have a workplace violence protection plan in place. So alert your clients, you got to do one yourself. We should have a model plan from the state here sometime in the spring, and it has to be in place by July 1 of this year, 2024. Okay, and then there'll be some things that have to be in it. The standard plan, the one from the state, will have all this stuff in it. I don't think it's going to be overly complicated. And then you have to do some training on it every year, and initially when you issue it, and then you'll have to do an every year training, which shouldn't be that complicated as part of the regular tailgates if it's construction or the lunch and learn kind of stuff, all of that. The other thing on that is, hold on, let me get to my notes so I don't forget any part of this. And you have to have 5 or more employees, which is probably a no-brainer for your group. And then initial training, let's see if there's anything else. Oh yeah, you have to keep records of potential violent incidents that occur. You have to keep a workplace violence hazard log. And that has to be kept for 5 years. And I think that's the basics. Let's see. Oh, so the companion bill and the employer rights thing, let me get to
John,
part of 32. Yeah, go ahead.
there's a question. It says, I read previously that the workplace violence plan has to be specific to your environment. Should this be done by us or by the client, by where the client is employee works? What's
Okay,
the
so for
recommendation?
your purposes, I would. Not sure what that is. Okay. I would have one for your white collar environment, and then your placements would be subject to the workplace violence policy at the host employer. That's another thing that I'm always a little ambiguous about with my clients on both sides of your relationships, whether I have the staffing agency or I have the host employer, is how do you handle the employee handbook for the host employer? Because there are aspects of that handbook that really do affect your placements. The harassment, if one of the supervisors on site is harassing them, what do they do? What do they do about safety? The workplace violence, of course, the COVID stuff, meals and rest breaks probably. So are you issuing the handbook or getting the handbook from the host employer and distributing it to your staffing people? Do they have to sign off on it? Those are all issues that you should work out with your host employer, because at the end of the day, let's say one of your temps got hurt and they said, well, I didn't know what to do, or I didn't know how to report it because I never saw anything from the host employer. Is that all covered sufficiently in your staffing agency handbook? Or do you need to bring in elements of the host employer's handbook and say, you're not subject to all aspects of this because you're not their direct hire, but there are pieces to this, including A, B, C, and D, some of the things I just mentioned, that you need to focus on. Something to think about in terms of shoring up your relationships later, in case there's a claim and you can show that you and the host employer did your due diligence on that issue. I hope that answered the question, because I forgot the question at this point. Oh yeah, you should, both the host employer and the staffing agency should have their own. Okay, and then this last thing, this companion bill SB 428, which I talked about, the issue there is that the conduct just would have caused a reasonable person to suffer substantial emotional distress and must actually cause that emotional distress. So that's another protection from abuse by various people. Okay. All right. And so you have an obligation to protect your people, and you may want to have something where your workers are able to get back to you and have that process clearly laid out, because they may be afraid to go to their people on the site. They need to come back to your rep and say, here's what's going on, and you need to make that clear that that's happening. Okay. 32, we are supposed to
John,
have,
there's a couple
Yep.
more questions.
go.
Do you think this is similar to harassment prevention? Can HRMs receive training or trainer, or does a specific type of person need to train? Lighter thinking about hosting a the trainer?
That's a good question. I've not seen anything that requires you to have like with the sex harassment training where you have to have someone who's trained to do it. Candidly, I can't remember if there's anything specific in this law about that. I don't remember that. And so I suspect that the people who are doing safety trainings are probably going to get versed on the workplace violence training so that they can include that in their package of materials that they're training on. That's where I think this is going to go. So if you've got people that do safety training, I would approach them first and see what they are doing, because you may be able to just throw it in their bucket and do it. But also, it could be just someone from your internal people who are up to speed on the policy itself. I'd have to look at the law again. I don't remember that detail, but that's how I'd handle it.
Okay, there's another question.
Yep.
Would you have to pay for workplace violence protection plan training, just like we pay for sexual harassment training?
Oh yeah, if you say to employees, you need to be at this meeting, they're going to have to get paid for it. And if they're called in on a special day, you may have to pay the 2-hour minimum unless you've scheduled the meeting in advance on a day that they don't normally work, but you've given them advance notice that today your schedule is 1 hour, so we owe you for an hour. Typically, I would pay for 2 hours. Or if it's a situation where they work their shift and then they have to come back and do the training, that's a little trickier, because when you call someone back to a work site, you're supposed to pay them portal to portal. There's no commute time in that situation. All right, let's get to maybe the biggie this year for a lot of employers, and that's the paid sick leave is going up. It's 24 hours, or was 24 hours. Now it's 40 hours or 5 days. Pay close attention to that 5 days. 2 examples. Clients on an alternative work week schedule, they do 4/10s. Well, their day is 10 hours, not 8. So 5 days for them would be 10 hours times 5 days is 50 hours. So they would be entitled to accumulate the 50 or front load the 50. That's one issue. There's no change in the one hour for 30, except they can accrue up to 80 hours and they can use only 40. The front loading is still legal. You just have to front load 40 instead of 24. Couple of points. Number one, so a lot of companies do the sick leave replenishment on the front loading in July, because that's when the statute was originally enacted in 2015. The problem is that on January 1 of this year, they were supposed to have the equivalent of 40 on the books, and you're not filling in until July. We have a gap. So what I would do is fill in the extra 16 hours on January 1, and this would be a great time to scrap the July time and just make it all January 1. Up to you. Or if you want to stick with your July fill in, then you'd give them the extra 16 hours in January so that they're trued up when it comes time to replenish in July. I think it's just easier to shove it all in now. That's one issue. The other issue is a little bit tricky. It's this alternative accrual that's in the middle of the screen here. The statute as written, the words on the page, is a little ambiguous as to when this applies. So here's the issue. What we think it means is that if you use something other than straight sick time, like PTO is the obvious example, or a different kind of accrual rate, that the employee has to have at least 24 hours on the books by the 120th calendar day, and no less than 40 hours by the 200th calendar day. Now, the problem with that is that if you've got a part-time employee, well, so here's the issue. It's not clear whether this applies to the accrual rate for sick time, or it only applies if you use an alternative accrual like PTO. And the reason I say that is because any law is supposed to be interpreted in a way that allows each of its sections to be enforceable. And the problem with this, if it's interpreted differently than what we think, is that you could have someone who's a 20-hour-a-week person, and they're accruing 1 hour for every 30, they're not going to have 24 hours by the 120th day. And so it doesn't make any sense that this 120-day thing and 200-day thing apply to the sick time accrual. Now, where this gets tricky, if we're right, and we've asked the Labor Commission for their opinion, we haven't gotten a straight answer, because I think they're looking at it going, yeah, this is confusing, is to treat it as if we're doing PTO, for people who are only getting, say, 40 hours of PTO in a year, that's not going to cut it because they won't have 24 hours by the 120th day. So you either front load the PTO to get to that amount, or you have a separate track with sick time during the first year to accommodate this number, or you give them more PTO so that by the 200th day, they'll have the 40 hours, et cetera. So it's a little bit of a wrinkle here, but nothing else has changed as far as carryovers and caps and forfeiture and use it or lose it. That's all still the same for sick time. And of course, if you got clients that are, well, that's probably not an area you're going to want to put your nose into the client's business, but I still see policies where the PTO and vacation accruals are capped at the same amount at which they earn them each year. So if they're earning 80 hours, the cap is 80. That's illegal. It needs to be 1.5 times that amount, which would be 120. All right, but I digress. All right, I'll pause. Any questions about this sick time stuff? Okay, good. All right, and of course, if there's a local jurisdiction like San Francisco or LA that has a higher number, you've got to follow that one. All right, and if they're subject to a collective bargaining agreement, there's some exceptions in there too. All right, 34, I don't know if you're placing low-end workers, but the lower paid folks are going to be able to get, or still right now get their paid family leave and SDI benefits at up to 90%, which is a lot higher than the normal. They're going, and that was going to sunset and end. Well, now they've extended it. And the way they're going to pay for that, if you look at the bottom of this section, is to take off the cap on the income that's taxed. It used to be capped out at 145,000. Now it's unlimited, and that will now pay for this. So that's probably fair. Nothing for you to do as an action item, however. Okay, so the federal regs on pregnancy, we have barely looked at them because we don't need to, because they're not as generous and restrictive in favor of employees as the California version. They're a long way better and a lot closer to California. So it's a little bit different, and you still have to follow California. So while this is a big deal in other parts of the country, it's not a deal in California. As long as you continue to follow California law, you'll be good to go. Keep in mind just one basic point is that pregnancy leave, there is no undue hardship defense. You have to accommodate. And then clients screw this up all the time. When you've got a pregnant situation, you've got the interplay with FMLA, CFRA, which is only 5 employees now, SDI, CFRA, paid family leave, pregnancy disability leave, CFRA, FMLA, SDI. If they've got postpartum depression, now you've got ADA implications. It gets very complicated with the alphabet soup. If you need help with parsing all that out or documents to give people notice, let me know. By the way, on that point, real quickly, I had this come up again this morning. It comes up probably almost every month for sure. John, it's been 7 months. I've been paying this person's premiums while they're out on work comp. When do I get to stop? Did you give them their FMLA or CFRA notice? No. What's that? Well, remember, when people go out on workers' comp, you must give them their FMLA or CFRA or both notice, because after 12 weeks, you can stop paying the premiums. Work comp does not require you to pay premiums, but those other 2 laws do, and they run concurrently. And so when the 12 weeks are up, now you can stop. So in this situation, as I always have to advise, let's get them on their FMLA now, and let's get the 12 weeks running so that at least at that point, you can stop paying the premiums, because they're probably going to still be out on leave. Okay. 36, probably not an issue for you all. This is just a reminder on this California consumer privacy. The only thing I want to bring up here is this, because there's no new law. It's just a reminder. and I heard a voice. Okay. So on this one,
John, there's a question.
okay,
For a company with only 2 employees, does PWFA apply to them?
does the what?
PWFA,
PWSA.
F like Frank, Paul,
Oh, the pregnancy
watermelon,
leave.
Frank.
Oh, well, certainly the California rules, you have to have 5 employees. And honestly, I don't remember if there's I gotta believe there's a threshold of how many employees you have to have. But I don't remember. If you want to send me the answer, or you can click on the link and see, but I don't know the answer on the federal rule. California, like pregnancy disability leave, you got to have 5 employees. Paid family leave, you only have to have 1 employee. California Family Rights Act, 5 employees. It's not a very good answer, but it's the best one I got. It says covered employers. I got to believe that there's a threshold of at least 5 and probably a little more. It's like the federal wage, the wage and hour laws. Under federal law, you've got to have 15 employees. The discrimination laws, 15 employees under federal law. So I would expect there's a minimum. And the only thing I want to mention here is this, from the CCPA, is the issue of the flaw in the statute when it was originally drafted. Essentially, you have consumer information on your employees by virtue of their personnel file. And a consumer could tell a company, you have my personal consumer information, I'd like you to delete it, erase it, throw it away, which will allow an employee effectively to do that. And so the state put a hold on that part of the law for a couple of years, and then they said, no, we're going to leave it as is now. Now, the good news is that you have a default to say, no, I can't destroy it. Now, I've never had anybody do this where an employee comes forward and says that, but your default response is there are other labor code sections that require us to maintain those records in the case of a request for wage information, well, a PAGA claim, that sort of thing. So you're not going to be destroying those materials. So that's very helpful in that respect. Give me 1 second. I'm fumbling around because I want to make sure I don't get my materials screwed up here. Okay, there we go. Let me catch up on my notes. I've been just kind of doing this extemporaneously here. Let's see where we are here. Okay. All right, what else? 37. Okay, so this is another category that you're not going to be discriminated against based on reproductive or sexual health application information. So here's what's happening. There are websites and there are apps that'll allow people to track menstrual cycles. There are algorithms to predict who's going to get pregnant, and companies are quietly using this to predict that so they can decide who they're going to promote. And, oh no, she's likely to get pregnant, we're not going to promote her. That stuff goes on. And as horrifying as it is, it's a reality. So California enacted this legislation saying that you can't use it, you can't rely on it, you can't discriminate based on it. And so it's just another way to protect employees and that kind of sensitive information. So you can throw that into the category of discrimination, that we won't discriminate on the basis of that phrase. All right, 38. So 38 relates to the Harvey Weinstein situations and the lawyer having a relationship with their employee, with their client, excuse me, or the movie director having a relationship with an actor. This is these situations, non-employment. And what would happen is you'd file a lawsuit against Harvey Weinstein, and the response you'd get was this barrage from the big bad law firm with piles of paper, a cross complaint for defamation, and all these things that would actually create a deterrent for employees to file because of this barrage that they would get hit with and now have to defend themselves. So California said you can't do that anymore, and it'll make it easier for people to make claims as long as they're made in good faith without malice. Standard that will have to be met, and most people will. So these big Harvey Weinstein reactions will no longer be legal. Okay. So just a reminder, that the reproductive health section, reproductive health making decisions, this was in response to Roe v. Wade being overturned. California is recognizing the right to an abortion. It wasn't specific to that in the statute, but this was the reason why we have it, that you cannot discriminate against someone for getting birth control, having an abortion, making reproductive health decisions. So action item, this will go in the laundry list of protected categories in your handbook. I'm going to skip 40. Mileage reimbursements going up. And mine are blank on the screen because this was prepared in October and I didn't want to redo my notes. So here's the answers. It's 67 cents a mile. That one went up 1.5 cents. The other one went down a penny. It's now, where's my notes? So it went down to 21 cents. And then the third one is 14 cents. That didn't change. The other thing to remember is the commute time issue. When does it morph into travel time? Well, do they have to stop at a yard to pick up construction materials? Do they have to stop at Home Depot before they went to the work site? Do they have to go to the bank or to the post office and pick up mail before they get to the office? Everything after those events is now travel time. And then in construction, it's even more difficult because these long commutes could be, 150 miles. Does it morph into travel time at some point? The law is not clear. We've had some lawsuits over this, and generally we've settled them, so we've never gotten a decision. I'm not sure it's relevant to your issue, so I'm going to skip it, but just be clear that people know what's travel time, what isn't, when is commute time, when isn't. Can you carve out some commute time on a long travel? Yes. If they're going to the airport to go to a trade show or something, their regular commute can be carved out from that travel time. Also, if you're just handing someone an auto stipend of $500 a month, the IRS is cracking down and you're going to need to have them account for what they're using the mileage, the stipend for, or it could be taxable. That's a good question for the CPA of how far you need to go with that. And just on the general comment about expense reimbursement, I'm still seeing claims for, wear and tear on my couch and my table from working from home because you told me to work from home. Just make sure that you're reimbursing your people for the reasonable expenses incurred on your behalf. It's not a fixed number like with the mileage, and the mileage is not a fixed number. It could be less, but typically we stick with the 67 cents. And when they issued this new mileage, they made a point of saying that the 67 cents applies also to hybrids and to electric vehicles, because there's always been an argument that maybe it could be 50 cents because they're just not spending as much. And also keep in mind, I've still got clients that give people a gas card and call it good. Well, that's not sufficient because that only covers gas. Wear and tear, maintenance, insurance, all those things have to be covered in it also. So the gas card is not sufficient. 42, just a reminder to get your posters up. The new ones. 43, this is kind of an interesting one. Let me just get to it. See exactly what I want to say on this one. Oh yeah, so this is the issue of an employee comes forward, complains about working hours, working conditions, whistleblower on some issue, and then within 90 days, for usually what's going to be business reasons, we hope, you discipline them or you terminate them. Now there is, under this statute, a rebuttable presumption that the action you took was retaliatory because it's so close in time to those complaints. Now it's rebuttable, meaning you can show the legitimate business reasons why you took this action, and that's fine, but this just reinforces the notion that you've really got to document carefully exactly what it is that was the basis for the discipline or the termination, or you could get nicked by this law. And that should be the case anyway. Paper is your friend. All right, 44 is a response to Alec Baldwin in that case where the cinematographer got shot. Not going to cover that. 45, I'm not sure anybody here is hiring minors, but the schools have to do, this is actually a different one. This is
John, there's a couple of questions.
Oh,
Regarding posters, what do you recommend for 100% remote work?
well, then I would use an intranet site or a web portal where they can access all of those documents online. Again, getting the opt-in approval that I talked about early on. That's really the only logical way to do it. All right, 46. I'm gonna
There's
skip.
just
Yeah,
two
oh,
more.
sorry, you said a couple. Go ahead.
No worries. Is the reimbursement policies only for private employers? Does it apply to public employers?
I'm not aware of anything different for public employers. And in fact, some of the wage order components, not the whole wage order, are applicable to public agencies. I would assume that the business reimbursement expense issue transcends private and public. I'm not aware of anything that says to the contrary. All right, 47 is a huge issue, and there's also, and we're going to get to briefly 103 at the end. This is a sea change in the world of unions. And remember, the National Labor Relations Act applies not just to union situations, but all employers. People forget that. And so there's a bunch of stuff that's come down, and we'll talk about it in a moment, that's made us really have to change our employee handbook. It's been a real pain this year. So here's the setup. A union is out proselytizing, trying to recruit people and get them to sign union cards. They go to people's homes, they have little meetings in coffee shops, whatever. They're allowed to come on the site of the company. The company can push back legally. There's certain ways that they can do that. And the typical strategy was the union would get the card signed. And once the union thought they had 51% of the workers subject to potential unionizing, hourly people, non-supervisor, they would go to the employer and say, we have 51% of your employees signed up for union cards. We want a vote. And there'd be a secret ballot vote. And then the company would often use a delay strategy to either at the front end contest the cards that have been signed. No, those aren't valid. Those aren't some of our people. And that would drag out for years in litigation. Or then there'd be a vote, and then there'd be allegations of inappropriate conduct in connection with the vote, and that would drag out for years. And that was a pretty simple strategy for the company to avoid getting to the bargaining table and actually having a union in. So the California Agricultural Labor Relations Board, through this California law, and now, more significantly, Federal National Labor Relations Board, we have a new world. So now the union comes forward and says, we have 51% of your employees signed up for union representation. You are now required to bargain. There is no vote. Now, the company can challenge the cards, but there's a very truncated, shortened process of 2 to 3 weeks that gets resolved. And now you've got 30 days to start bargaining. So the advantage of having a secret ballot vote where employees now could be free to choose and not have the peer pressure of sitting around the dining room table with other workers, that's gone. And all of these strategies that the employer used to delay the process are now gone. This is a huge change in the law, primarily designed by, obviously, the more liberal National Labor Relations Board. It's controlled by the Democrats right now. They're pushing all these things, and that may flip-flop depending on what happens down the road, but that's what we've got right now. It's a huge deal. 48, some bills didn't pass, don't have time. 49, this may be relevant. Minimum wage going up $16. It's that 3.5% increase the governor's allowed to do. That's every employer. There's no carve out for smaller employers. And remember what that does to the next paragraph down here, just above the note. The minimum wage is keyed, the salaried exempt test is keyed off of the California minimum wage, which is now going to go up to $66,560, which is $16 times 2, double minimum wage, times 2,080, which is 52 weeks times 40 weeks. That's how you get 66,560. Now, you cannot add in any commissions or anything else. There's a case in this pile of documents of a guy who was making $200,000 a year, but he was paid a daily rate. And he had a bunch of overtime, but the company assumed that he was a senior executive. The daily rate covered it. What's the big deal? Court said, no, he was not paid an actual salary, and therefore you owe overtime. So be aware. And you can't add in commissions like the federal law allows for their salary rate. The other thing people forget is if you're in an area like San Francisco or LA that has a higher minimum wage, you do not use the local jurisdiction's minimum wage to calculate the salary test. Those are two different concepts. You use the California minimum for this. And remember, it's not just salary, it's the duties test. You got to be doing more than half your time doing exempt stuff. And for those of you with inside salespeople, which you all have, with your recruiters, you've got some very tricky areas with the use of commissions or bonuses where you have to pay them potentially overtime if their commissions do not exceed their base rate in a pay period. You cannot pay monthly, and then every other pay period they get a big check on commissions, which exceeds their base. That's great. But the other pay period, when they only got their base and no commission, you have to pay overtime because they got no commissions that exceeded their base. And it gets a little bit tricky. And outside salespeople, you're fine, but they're not outside salespeople if they spend more than half their time at home or in your office. So for those of you who have issues with that, with your admin people, your recruiters, this is something you need to take a hard look at because you may be doing it wrong. There's going to be a federal increase in the minimum salary to 55 is proposed. This is not law yet. Irrelevant in California, and they have a little deal where they can add 10% of that 55 can be commissions. And then the 143,000, that highly compensated employee, irrelevant in California. We don't have that exemption. It's not recognized here. You can't use it. And that would be someone who's not a salaried exempt worker, but they make over $143,000 and have a tiny bit of management, 1% is all it takes. Then they're excluded from overtime, but not relevant in California. 51, for those of you who recruit in this space, the rate's gone up, you know who you are and what that's all about. Same thing with doctors. There's an exemption for them to be paid hourly and not get overtime too. All right, the mental health area, if you're recruiting in not mental health, healthcare, if you're recruiting in this area, we've got this new law that is being contested, and we'll see what happens. But medical offices with at least 25 physicians, hospitals, all kinds of healthcare facilities. There's a bunch of them covered. There's several that are not covered. Minimum wage for all workers in this space is going to phase in over time to a maximum of $25 by 2026. Now, typically when there's been healthcare legislation like this, it only affected the actual healthcare workers, not the back office accounting people or the billers or the janitors or anybody like that. Those people are all now covered by this law. But there's a lawsuit just got filed. We'll see what happens. But it's very specific about who's covered, this long list here, and then who's not covered. There's some small exemptions, which you can see here what's covered and not covered. Okay, I'm going to skip the details. If you're in healthcare or supply to healthcare, you may want to become familiar with this, but this is going to be a long road here with this lawsuit that was filed. All right, the wage theft notification form, you all probably have this in your hiring packet. It's been updated as of November. You can go online and pull it off and just send it out. It's got a couple of new pieces of information. They've included things about meals and rest breaks now, which is a new one. It used to just have, here's your sick time, here's our workers' comp carrier, and here's your wage. When you update, when somebody gets an increase in salary, you do not have to issue them a new form because it will show up on their pay stub, and that's notification enough. And you do not, as far as I can tell, you do not have to reissue this form to all your existing workers, just to new people. But it's up and running. I pulled it off. It's in our system now, and it's at electronic forms. It's pretty easy to deal with. Work permits, schools are going to have to train kids on what it is to be an employee, what their rights are. And when you go to get a business license, the Labor Commission is going to have to hand out a little form that says, here's your rights. No, I misspoke. The kid's going to get a form saying, here's your rights and obligations as an employee. Got that confused with something else. All right. So we've got about 30 minutes for the new cases. If you've got any clients on alternative work weeks, and you may, where you're placing them, your worker just gets slotted in and they're subject to the same AWS as everybody else, you might want to take a look at how the employer implements it. And just as a matter of curiosity, I think it's a good idea for you to go online to the labor workforce and statistics. I forget the exact title, but if you type in alternative work week website, California, you will get you can type in the name of a company and it will have a list of every company that has an alternative work week and has properly implemented it, in part, including a letter to the state telling the state that they did it and some details there. And you can find out immediately if you're placing a worker in a work site with an AWS that's properly done, or at least they got it to the state. Whether they're implementing it properly is a different story. Arbitration, not going to get any more detail there. I think I talked about making sure that you have signed, maybe I didn't cover this with this group, but I've done this 4 times in 3 days. So I'm a little addled on this. But we're still subject to PAGA cases. We can't get out of those, despite the Viking River Cruises case. Long story there. There's a couple cases now that say that management needs to sign the arbitration agreement so that it's a bilateral agreement. And we've had situations where the employee signs it, but then it goes in the file unsigned by management. Make sure that gets signed. And I'm going to skip the rest of this. There's a whole bunch of stuff about arbitration in here. The other thing that comes up is the electronic signature. And if you can get a wet signature, that'd be great, and have them scan it and send it back to you. We've had now a 3rd case is pending, but we had 2 in the past where the employee says, I didn't sign that. And electronically, that somebody in HR must have gone in and signed it. And we won both of those cases because we were able to prove from peripheral documents, like an email that said, okay, I've signed everything, or here's the list of everything I signed. But just make sure you've got some sort of fail-safe method for ensuring that you can prove that they signed an e-document. And that would be the one document I'd like on a wet signature. All right, skipping on. I've got some tabs on my materials that will take me to the ones I want to talk about. So just bear with me as I go through these. 58 is the next one I want to talk about. Of course, I just scrolled right past it. So this just reinforces, this is a woman who was on intermittent FMLA. Maybe she was getting chemo on Wednesdays afternoons and she needed to be out on Thursday to recover. I don't remember the details, but in any event, she had chronic absenteeism and was disciplined for that over time, and it had nothing to do with her intermittent FMLA. And so because they had done such a good job as a company of documenting all of her warnings and all of the issues, the company won the case. But it just reinforces how important it is to document issues with employees. It's going to make it a lot easier to defend these later. Okay. Just quickly on number 60. Here's the setup on this real quickly. Is we had this case called Naranjo that's referenced in here also, but it's also part of this. And the Naranjo case was employees suing for meal break premiums and rest break premiums. Should they get their attorney's fees? And should they get 30 days of waiting time penalty if they've left the company? And are these the type of unpaid wages that warrant paying the waiting time penalty? And the court said, the appellate court said, no, these are not wages for work performed, so it's not the type of wages that warrant those things. And frankly, the attorney's fees and the waiting time penalties are an enormous percentage of the value of these cases. So that was great. But then along came the California Supreme Court in the Naranjo case, number 84, and they said, oh, no, appellate court, you're wrong. Those are the kinds of things that are just like any other kind of wages. You get your attorney's fees, you get your waiting time penalty. So it all went to hell for us. So that was bad. 61, this probably relates more to your administrative staff than your placements. People who get production bonuses or longevity bonuses, or we'll pay your sick time at the end of the year, or a company-wide, if we make our sales targets, everybody gets $500, or you get a percentage of your inside sales, but you don't get enough to cover the base, so we have to pay you overtime. Or they just, they get 60,000 base and their commissions or their bonuses are low enough that they'll never hit that threshold. You have to pay overtime on that stuff. What companies forget routinely is to gross up those bonuses or commissions based on the amount of overtime that they worked in the pay period that it applies to. If it's an annual longevity bonus, you have to go back the whole year and figure out how much overtime they worked or how many hours of overtime. And there's some math you do to gross up that bonus. If it's $1,000 bonus, it might be $12. it's cheap, but you got to do it, or now you've got all these penalties. If it's quarterly, you do a quarterly look back, and it relates to 3 categories: overtime gross up, sick time and PTO gross up, and not vacation so far, and meal and rest break gross ups. So if somebody's getting $30 an hour and then they got a bonus of some number, their hourly rate may go up from 30 to 32.50, and you'd have to pay overtime on 32.50. There's a lot more to it to that. And then there's something that this 61 relates to, that a percentage-based bonus, which is a fluctuating bonus, versus a flat sum bonus, the math is different. It's actually more expensive for a flat sum bonus. I won't bore you with why, but if you've got this situation, either with your placements or your in-house people, you got to talk to me, because this is a hot button area that the plaintiffs' lawyers now for several years have picked up on. My very first one of these, which was probably 20 years ago, before anybody ever even heard of this issue, I represented a phone sex company, that big business. They did about 20 million a year. And they'd keep people on the credit card, and they'd have a horse race literally on the wall with their little horse. And whoever had the best hold times, generating more income, their horse would move to the finish line and they'd get the bonus. And they weren't getting paid overtime on those bonuses. We paid about $7,000 to get rid of it, but that was the very first one I ever had. Okay, 62, just more on business expenses. IBM had a creative argument that during COVID, we sent everybody home and we didn't pay their business expenses. Why? Well, because we didn't tell them to go home. Governor Newsom did. It was his fault. And the court said, no, because you required them to stay home for whatever reason, you got to pay the expenses. So that suggests people working voluntarily from home, we don't have to pay their expenses. The other thing is, if you're paying the expenses for home-based workers that you require, that they're working there because that's what they're told to do, or it's deemed to be a remote position, you got to pay them something. At least I pay $50 a month to my attorneys for their phone. I pay it 3 months at a time, so I don't have to write so many checks. But the key thing is, for most situations, you've got to make sure, what are we paying for? If it's just screens, phone, tablet, computer, fine. But what about internet bandwidth? Well, we had claims for air conditioning. I have a dent in my couch because I was sitting on it all day. So make a list of all the things that it could possibly cover, so somebody can't come back later and say, you didn't cover this.
Okay, and John, just one real quick. I know you moved on already, but
Okay.
going back just real quick, the bonuses. Is it just non-discretionary?
It is just non-discretionary, but be clear that it really is non-discretionary. So like a holiday bonus, it's expected, you do it every year, but that's not a non-discretionary bonus. It is discretionary. But as soon as you set a condition, it's now a non-discretionary bonus. You do this, we will do this. You get through the whole year without being on probation, we'll give you $300 as a longevity bonus. A recruitment bonus, this is crazy. Because you'd think these should be based on production. California says that if I give you a $250 recruitment bonus because you found me a worker and they stuck for the 90 days, I'm going to give you $250. That has to be grossed up as a non-discretionary bonus. Federal law, in contrast, says, no, that's not a non-discretionary bonus. And this isn't just California, this is federal. In the federal regs, there's even an example that cites, if you pay out sick time, that's a non-discretionary bonus. And you'd have to gross it up based on the whole year. That's it? Okay.
That's I think everybody's digesting that one.
Yeah, that's a very scary area. And everybody in my office, when we get one of those, they send it to me because I'm the only one who knows how to do the math. Go ahead.
Oh, no, that's just I don't know where that noise is
Random
coming.
talk. Okay. 63 was good news. Guy brings home COVID from the office. His wife gets it. She sued the company saying, I got it through you. And the court said, no, there's no obligation to the wife. That would have opened up the floodgates. So that was a good thing. 64, remember, you can only go back 7 years under California law. So I have a national employer that's been doing the background checks from their Midwestern location, regardless of where their local sites are. And they've been feeding information to their California sites that is more than 7 years old. And we had a problem recently about that. So just be careful that you're not getting over 7-year information. All right, let me look at my list here. 66, just real quickly, this reinforces why you need to document. And the facts aren't critical. But this is what we call the McDonnell-Douglas test. And this has to do with the three-step process of why this documentation is so critical. So employee claims discrimination. They file their lawsuit, and they have the initial burden at step one of the three steps to make what we call their prima facie case in the first instance. And they have to demonstrate some basic stuff. I was employed, I'm in a protected category, a bad thing happened to me, I got fired, and the firing was at least tangentially related to my protected category status. And they don't have to show much. That then shifts the burden to step two, which now falls on you as the employer. You have the burden of what we call the burden of persuasion. You have to show enough business reasons that were legitimate to now move the case to the next level. And in that level two, that's all your documents. No, we didn't fire them because they're old. We fired them because of these business reasons. And here's all the documents to back that up and our witnesses. Once you've met that second level burden, the ultimate burden of proof goes back to the employee to show that those level two business reasons were all bogus and a pretext for the real reason, because they were old. And then the more paperwork and the more strong your second level proof is, the higher the burden on the employee to beat that amount or those issues in the third level. And little things will come back to bite. I got a case right now I'm trying to resolve. The opposing counsel is my playmate when I was 4 years old. And so we've had kind of fun with that. And he's kind of annoying, but he was then, he is now. But his client was older, and people were joking about her using an abacus to do her accounting functions and some other sort of dinosaur type comments. And they were in jest, and she would joke about it, and she'd talk about retirement. And one of the guys making the comments was 69 years old. Well, now, of course, when she got pushed aside to a lesser position, she's now claiming age discrimination. And look at all this evidence of age discrimination. So you just got to be careful. Okay. What else? I want to hit a couple of issues that just generally, if you or your client is rounding any time now, stop it. Legally, you cannot round meal breaks. I did an HR audit on Monday with a client. They were rounding meals. 29 minutes became 30. That's illegal. You legally can round the beginning and the end of the day, but don't do it, because every rounding study, I got one this morning from a client, I haven't looked at it yet, I'm sure it's going to be terrible, that when you round, it almost always favors the employer. And because of that, the courts have cracked down on rounding and saying, we don't care that you did it legally as far as the 15 minutes round up or down, which is still legal. But because it so heavily favors the employer so often, you're dead. And the reality is that's what happens. They clock in a couple minutes early so that they're not late. And they clock out a couple minutes after their end time so they're not leaving early. And they just lost 4 minutes. And over a week, that's 20 minutes. And over a year, that's 1,000 minutes. And over 4 years, that's 4,000 minutes. Well, that's real money. So now you're dead. So no rounding, and check with your clients, make sure they're not rounding just for their own good, because it could come back to bite you in a part of a class action, for example. And then on meal breaks, it's hard for you to get your clients to do something to protect themselves and your people, but meal breaks is still the biggest Achilles heel that you've got. And on meal breaks, what I've been suggesting is a few things. My number one favorite thing is a drop-down menu at the end of the day for the hourly worker, that before they can finish clocking out in a POS in a restaurant or in an electronic system or on a computer or at a kiosk, before they clock out, they're going to get at least one and maybe two drop-downs. The first one is rest breaks. Since you're not going to record them, and I still say don't record them. It's a dumb idea because they'll forget half the time. Did you get your 2 or 3 rest breaks today? Yes or no? If yes, you're done, you go clock out. If no, then why not? And there's a couple categories for the boss made me do it, business was too busy. And then there's a couple of I did it on my own, or I forgot, didn't want one. Depending on which one they check, you're paying the premium or not. And if they did it on their own, you're not paying the premium and you've got a record of it. And if they check the boss made me do it, you're going to crack down and find out why and try to put a stop to it so you don't have all these rest break violations. On the meal break side, I've been dealing with I've got a client that uses one of the big payroll services. They have the stupidest meal break attestation I've ever seen. First of all, it's illegal. It's not right. You have to take your meal before. Did you get your meal before the 6th hour? Come on, really? And then you get 2 meals you get a meal for each 5 hours you work. Not correct. If you work 10 hours, you're not entitled to a second meal. And it doesn't have to be because you work between, you got your meal at 3 hours and you finished at 3.5 hours. And then 6.5 hours later, you clock out. You don't get a meal for that 6.5 hours just because it was over 5. So it's just dead wrong. That was number one. Number two, another one I looked at said at the end of their pay period, I attest that I was paid properly for all my wages for this pay period. And I got all my meal and rest breaks. Well, the problem with that is they haven't seen their paycheck yet. So how can they attest to it? These are big payroll services, big ones. This is just idiotic. So the second drop-down menu would be for the meal break. I have a client that I've invested money in their company because I help write their software, which only drops down when the algorithm detects a violation. Was it short? Was it late? Was it not recorded? Then they'll get a meal break attestation that's essentially like what I just described for the rest break. Other drop downs will come anyway in some of these other systems I've seen. Did you get your meal break today by the end of the 5th hour? And then yes or no, and then you go through the whole process. That to me is the safest way to protect against this stuff. The other one that I love is the 30-minute lockout. You clock out, you cannot clock back in for 30 minutes. The system won't let you. Now, by doing that, it's very difficult to hit it right on the button at 30 minutes to clock back in. So you give them a 2-minute grace period. Now, I know you as the staffing agencies have really no control over what your placements are doing on site because they're subject usually to the whim of the host employer system. If you have your own setup over there, then maybe you can implement some of these things. But because meals and rest breaks are still your biggest problem, I think you really need to pay special attention to those two subjects and clean it up. And also, somebody's got to be looking at timesheets every day if you don't have an electronic monitoring system to see if there are violations. And also double check. I have a client right now that we're going to mediation in February. I did an HR audit with her 6 years ago, and she instructed her accounting department to stop rounding. And 6 months ago, when she got sued, she wasn't worried about that because they weren't rounding. Well, when she checked with her people, sure enough, they were rounding. And then she had one site for a big company, she does janitorial. That site, the supervisor didn't understand the rules, and all his people were taking their meal at 5.5 hours. So, and she had no idea because nobody was checking the time cards. So this is the kind of stuff that can bite you as a staffing agency also, particularly with your placements. All right, what do I have, about 10 minutes? All right, let's see what we got here. Well, let's go to 72, why not? There's a bunch of discrimination cases in here. These are my least favorite, is disability discrimination. Tread lightly. So the equal pay stuff, the key thing there is, and it might be, yeah, 71. Just a reminder that if you've got workers that are, mixed bag of men and women, just make sure they're being paid consistently. I still have an agricultural client, that when they call into their contract, their labor contractor, I need 2 heavies and 1 light. That's code for I need a couple of men to work in the heavy, the big load positions. And I need a woman to work on the sorting line because it's lighter, it's not heavy duty pickup stuff work. Totally illegal, but that's what they do. And if you do an equal pay audit of some sort for any reason, copy your attorney so that it's privileged in case you do have some bad stuff. All right, what else we got? So this is directly related to you guys. A lot of you may know about this. So employees working for a staffing agency, they get a temp position at a bank. The bank assignment ends. And so the employee alleged that because she was discharged from the bank and therefore the staffing agency, she should get immediate wage payment because it was a termination. Staffing agency logically contended that she was still on their payroll and was eligible for reassignment, even though she couldn't return to that specific host employer, the bank. And thankfully, the Court of Appeal ruled that this was not a discharge for purposes of employment, and therefore you did not have to pay immediately. So good news for staffing agencies. Now, if you terminate someone, they're not eligible for rehire because they did a bad thing at your client, that probably would be a different result here. So just pay attention to that issue if it's an issue. 74 relates to this issue of final pay. This all came up during COVID, and the Labor Commission has this specific rule that if a furlough is for more than 10 days, it morphs into a layoff and you have to pay out accrued vacation or PTO. So just be aware of that issue if it were to come up. All right, what else we got? Right.
And then too, John, what I was
Yep.
hoping to too, because I know we're really running it in, is just kind of go over all your action items. I've been kind of keeping track of your action items, just to hone that in. that
Okay,
people-
let me finish one thing and then we'll do that. Let's go straight to 103. Okay, come on. Oh, be careful with employees who may have some pre-clock in things like booting up the computer took forever. I actually had an employee in my office where she just randomly made a comment one day and I thought, oh, we better pay her an extra 5 minutes until we get her a new computer. So that was one thing. But if they have changing requirements and they have to change into special equipment, or it takes a long time to get to their workstation, those may be things that are not being paid, and you have to be careful about that. The other one is the net 10 minutes on rest breaks. So you got somebody in a construction site working on the 4th floor, and it takes forever to get down the elevator to the break site. The net 10 minutes doesn't start till they're back at the site, at the break site. So all that time getting to and from the site doesn't count. Sometimes clients screw that
Oh,
up.
Richard,
Oh, tell Richard to mute himself. Okay, so
hey,
103
Jim,
is,
good. Where are you based out of?
we're very happy that Jim's based out of somewhere.
Boston on the 128. I
not
used to work
sure-
for one of the
not
companies
sure
here,
how
Open
that's
Market,
happened.
which is right on the 128 quarter back in the mid
I know,
90s.
Eric, are you able to see where that's coming from?
Yep, right on the Beltway in 128,
wow.
about 10.
All right,
Okay,
good
That's
stuff.
Richard Rue. Let me see if I can, oh, I think he did it. Okay, perfect.
There we go. Put a D on the end of his name. Sorry about that, Richard. Okay, so let me get to my notes on this stuff. So the big deal here was H, the Cemex case, which I talked about earlier, which eliminated the union voting. The other incredibly big deal is E, the Stericycle case from the NLRB. So this is why our handbook has been modified pretty radically in several places, and we put all kinds of disclaimers about this policy is not intended to violate Section 7 of the National Labor Relations Act, which covers unfair business practices or unfair labor practices. And so the upshot of this Stericycle is the NLRB is encouraging union organizing, concerted action, that sort of thing. So things like, is there a camera in the hallway? Well, why? Well, we have it there for safety reasons. In case somebody gets hurt, we want to make sure we're monitoring. And that's probably not going to be allowed. By the way, again, probably not your problem, it's the host employer, but having audio on cameras is a very bad idea. Because we have to have third-party consent. Policies that say you can't say anything negative about the company in a social media post or internet, that's not allowed anymore. You can't do that. They may do, unjustified failure, refusal to do a particular action. You've got to temper that with language like it was unjustified, because the employee could have said, well, there's a safety issue, or I'm not going to perform that task. Well, you can't punish him for that. So we've got all these things now that are requiring us to back off on some of the prohibitions that would be normally in a discipline policy. These are the rules of conduct. You can't do 1 through 27. Well, we've had to modify several of those. So that's become a huge issue, and we've modified significantly our handbook. My strategy these days when clients want to do a new handbook is to say, the cheapest way we do it, it's a flat $1,500, is you get us your handbook in Word format. We will integrate it into our master so we know it's all correct. Otherwise, it could take twice that much time to try to fix yours. It's just not worth it. So just a ton of issues now from the Stericycle case, and the burden's going to be on the employer that anything you do to inhibit this kind of stuff, the phrasing at the top of the screen here, the reasonable tendency to chill protected concerted activity, it's going to be pretty easy for employees to say that. And the burden's going to be on the employer to say, why do you have this here? And is there a less intrusive or oppressive means to accomplish what you're trying to accomplish. All right, now, so to your action items, update the handbook, figure out how you're going to best monitor your temp or your placements, meal breaks and rest breaks, working in concert, perhaps with your employer, using your own timekeeping system, getting a drop-down menu, making damn sure nobody's rounding time. What else? The gross up issue on the commissions, which is a big deal for your staffing professionals. I know some of you are screwing that up. I can guarantee that. Outside versus inside sales. Are you properly paying your admins? Are they allowed to be salaried, or are they misclassified? Those are issues that you want to talk about. One little strategy I do with that misclassification issue is someone who's maybe close, but they're on salary, they want to be salaried, have them parse out their job description for the essential and non-essential I'm sorry, the exempt versus non-exempt functions, making sure we all agree that they're exempt functions, and then have them ascribe a percentage that they spend on those functions to see if they meet the 50% test. And then when they do, and they've signed off on it, the next year at review time, have them reaffirm that that's still accurate or not, so that when they get fired and they go to an attorney and claim all this overtime, you can point to in their own hand, they validated that they were over 50%. It's a great strategy. And I've done it a few times and actually was able to use it in response once to a claim. It's not going to come up very often, but it was great. All right. I think that's all I have. If there's anything else you wanted me to focus on briefly, I'm happy to do it.
Hey, everyone, this is your chance to feed those questions in. If you have any more questions. And the other thing, I think one of the action items I had starred was the arbitration, just completely
Oh, yeah,
looking
yeah.
at it.
Arbitration agreements, 100%, you should have those. And check on EPLI if you don't have it. And then the nuance in your contracts with your host employer, who's footing the bill for the deductible if you are covering the host employer for some reason.
And then another thing that a lot of people,
I don't know if you got any PEO people in your group, but that would be an area for that also. Go ahead.
oh, I think we do. Yeah, I think we do. So all you PEO folks, listen to that. Okay. And the other thing that I thought was something we probably need as an action item on all of us is definitely look at our handbooks. And then if we have any questions or need help with handbooks, we should probably reach out to you.
Great. The other thing that I would do, if you are interested, if any of you want to get together collectively and do the HR audit and share the cost, a lot of you are going to have the similar issues. And instead of spending 4 or 5 hours of my time at my ridiculous rate on your own, share it with the others. I don't mind doing it as a group. So that's another thought.
Well, John, I'd like to take this moment to say thank you very much for your time and all the energy that it takes to actually understand all of this. You know, being an employer in California is a big challenge, and having unemployment law specialist attorney such as yourself, someone that we can reach out to, we really do appreciate all that you do. So thank you.
You are welcome. I see a question in here about a host client offers paid lunches. Does the offsite lunch requirement still apply? Well, you have to make it clear to your employees that they could still go offsite, that they're allowed to leave the premises, and just the fact that the employer is paying for the meal doesn't eliminate the requirement that they be given the opportunity to take an off-duty, off-site meal. And if they're doing like a lunch and learn, that's paid time, and you have to come up with another. If it's a required lunch and learn, you got to find another way to get that half hour in. But that's a different seminar. Anyway, I just happened to see that in the queue here. And the PDF is available. I'm happy for you to distribute this to your people. It should have been in the materials I sent to you guys. So that's fine too. All right, that's all I got.
I think the plan is we'll be sending out to all the attendees.
Okay.
Yes, yes,
have
we'll
it. We
definitely
want
do
them
that.
to come.
Yeah,
Right.
we do appreciate that. We do have some additional upcoming CSP events, and I know, Michelle, I don't know if you're going to quickly review those, but you know, first and foremost, thank you very much, John, for all that you've done.
You're welcome. I gotta rest my voice for next round at 4:30.
Perfect.
All right,
Okay,
guys.
great.
Bye-bye.
Bye-bye. So thank you again all for joining us. We recognize that there is a lot of business to be done at this time of year, so we don't want to keep you. We want to remind all of you members and potential members that we do have 2 upcoming events. The in-person event that's coming up that you'll see on your screen right now is the Legislative Day, which is February 6th and 7th. As you know, legislation is a huge aspect of being a successful employer here in California, and helping just really helping somehow suggesting to the legislators of the great state of California, what could potentially help us. We do live in a very liberal state, but if there's something that we can do is really be vocal about what can help us. So that is the key component of this legislative day, and the push is to really make sure legislators know what these rules do to our business. On top of that, next week, actually, we also have an event on Thursday. It is a Women in Staffing lesson from the trenches. This is another wonderful Zoom opportunity for you to hear from some greats in the industry and what they have been doing with some very big challenges they've been facing over the last year. Michelle, do you have anything to speak about just with reference to either of these events?
I was listening with rapt attention. No, I think you covered it. The thing is, we really want you to feel welcome at all of these events. We'd love to have you as a member, and our gal Sylvia there that just was talking, you want to reach out to her if you have any questions about membership, and maybe for people who joined us late, go over that special. But also don't leave just yet too. Is that number 73? Go back to number 73 when you have a chance. When you get the handout, part of that law was something that goes back to the way the staffing firms get their final paycheck, sort of breathing room on final paycheck if you're not completely terminating someone. Part of that CSP had something big to do with it many years ago. It goes back into history, but that's part of our legislative work that we've done and the value that we bring to members. I mean, they're protecting your paycheck, your company, and we're behind the scenes doing it. And so that legislative day, again, really important. And membership, we just have the coolest bunch of hardworking people working together. And we have one firm doesn't have a lot of power, but all of us together, we have a lot. And remember, if you're not in California yet, or planning to be, or not in California, but you're interested in this, what goes on in California does not stay in California.
It is true. It's true. We're often the bellwether when it comes to laws and legislations when it comes to this. So certainly knowing more about this will help not only your business, but certainly interacting with your clients and being that true advocate, being that true consultative, knowledge base for your clients, so that you can really talk about some of the legislation that is happening and the upcoming legislation that we're looking at. So yes, if you're interested in joining the CSP and you have not joined, we really encourage you to join. If you are interested in joining before the end of the month and have paid for this particular webinar, please do reach out. We do have that special going on right now for staffing firms that are one office. Basically the fee is normally $400 per office. And so definitely wanting to speak with anybody that's interested. And of course I am here at any time. You can contact all of us, honestly, but I will make sure that I'm going to be sending my contact information out to all of the individuals that are not CSP members. I believe we had about 120 people join us today. Is that right, Michelle?
I think it was 122.
Okay, so of the 122, I do know some individuals were not CSP members, so look out for your email from me. within the next week. And we definitely look forward to reaching out to each and every one of you. And for the fabulous members that we do have, thank you also for attending. We really appreciate all of your support. We do have some industry members online as well. And here are some gem level sponsors that we have. I absolutely love our sponsors, and a lot of the industry partners that we have provide services that are really key to our industry and our success. So if you haven't been made aware of these organizations and what they do, let us know, because we want to make sure that you know what these organizations can offer you as a business overall.
Yeah, and a few of our vendor partners our industry partners were online today, here to support you. They heard what you heard. And another membership benefit is everything gets put into our website too. You 24/7 access to it, and you can reach out to members all the time if you need help on a resource. All of our information's on there too. Just want to mention that too.
Absolutely.
Other upcoming things too, besides next week, which is very busy, right? We've got an event on Wednesday, and then we also have, which is a legislative call. And you can join that call just right away, get involved. And then our Women in the Trenches. But upcoming in June is our annual conference, and it's a great way to meet a bunch of people and get a real boost from all that. So there's things going on every month at CSP. We hope you'll join.
Yes.
Call Sylvia.
Yes. And we will also be reaching out to you. But yes, we really do have a lot going on this year. And that is because, in fact, it is a challenge to stay, on top of what we need to know as staffing employers. So thank you all for joining today. And we're looking forward to seeing more faces at these next events. Thank
you. And John, if you're still there, thank you again. I don't know if you had.
I think he did leave, but thank you. Yes, thanks. That's not an easy thing what he just did. So we do appreciate all that he put together for us.
He's amazing.
So thanks again, everyone. I don't think we have any additional questions, and we hope that you have a great rest of your afternoon.
Take care.
Bye.